period of up to 9 months for any single violation, but there is a cap or limit of half of whatever prison term the judge imposed for all violations. However, if you commit a new felony while under post-release control supervision, then an additional ever sentence the judge in that new felony in case you impose the felony, that judge is also authorized to sentence you for committing that offense while under post-release control. In this case, to an additional period of 1 year or whatever time left on the periods of post-release control, whichever is greater. If that occurred, that would have to be served consecutively sentence in the new case. You understand that? Now, this is not a mandatory prison sentence offense in either case, although that's typically what's given, but it is possible under the law that a person could be put under community control rather than being sentenced to prison. That's the same thing as probation. So that means you would be supervised by a probation officer on the term set by the court for a period of up to 5 years. And if during that period of time, the probation department felt that you were not compliant, they would have to file written notice of that reports or copy on you. There would be a hearing, you'd be entitled to have an attorney. And if the outcome of the hearing was that you failed to comply, then at that time the court could impose a sentence of 120 months, fine, and $20,000 for both counts. Do you understand that?
Yes, sir.
Right now, the first count of the indictment alleges that on or about period April 1, 2020 through September 1, 2020 in Highland County, Ohio, you did engage in sexual conduct with a CW, not the spouse of the said Matthew B. Henderson, and that you, being the natural parent, adopted parent, step parent, guardian, custodian, or person in local premises CW. The violation of section 2907.0385. The second count alleges that you did the same thing except it was on or about September 8, 2020. Otherwise, it's the same allegations and the same offense. So again, that's a third-degree felony. Each of those are possible prison terms between 9 and 60 months and a fine of $10,000, plus the designation of the sex offender. Now, Mr. Henderson, do you understand what it is you've been charged with in those two counts of the indictment, what the state said you did? When, where, and how they alleged you did it?
Yes, sir.
Have you discussed the nature of those charges, the evidence in the case, possible offenses you might try to raise in trial, possible outcomes of a trial with your attorney and your attorneys? And are you satisfied with their advice and confidence in this matter?
Yes, sir.
Now, are you under the influence of any types of drugs or alcohol at this time? Has anyone threatened you to make you plead guilty here today? All right, now the core of the last 5 sentences on page 2 are printed in bold and underlined, and they read as follows. Defendant shall enter plead guilty to counts 1 and 2, stating will dismiss the remaining counts, state defense shall only recommend 60 months on incarceration on count 1, consecutive 48 months on count 2, for a total of 108 months or 9 years. Defendant shall be a tier 3 registered sex offender. Is that your understanding of the agreement? Does anyone promise you anything other than that in case you plead guilty here today, Mr. Henderson? Now, under the law, Mr. Henderson, the matter of sentence is up to the judge, so not the parties. So, if you plead guilty, even though there's a recommendation to get that number of 108 months total, I have the authority to impose any sentence between the ranges that are provided 9 and 60 months on each case consecutively. You understand that? Now, do you hold any license or certification from any state agency that regulates any profession or occupation? All right, and you have certain constitutional rights you need to understand before I can accept the plea guilty from you, Mr. Henderson. First of all, you have a right to counsel. In this case, I appointed Mr. Armstrong and Mr. Wagner to represent you as co-counsel. Now, the purpose of that wasn't simply to work the case out, but to provide any defense that may be available to you under the law that you would like them to provide. So, if you decide that you do not want to plead guilty, that you want to defend and fight against these charges, they'll continue to represent you and defend you, including a trial if that's what you want. You understand that?
Yes, sir.
All right, now, under the Constitution, Mr. Henderson, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens who live in Highland County who are summoned for jury duty on your trial. After the 12 jurors are selected, the evidence is presented and they're instructed on the law. And then that jury of 12 would have to decide by unanimous verdict whether or not the state proved your guilt on this, either or both charges. And that verdict would have to be unanimous in each count. meaning all 12 jurors would have to agree to the verdict of each of the two counts. Now, if you didn't want to have a jury trial, if you didn't want to plead guilty, you can waive, which means give up and right to have a jury trial. In that case, you have what's called a court bench trial, meaning that instead of the jury hearing the evidence, it would be the judge who would hear the evidence, apply the law, and decide whether or not state proof or guilt or would be on reasonable doubt. You understand that? All right, now, Mr. Henderson, under the Constitution, you have the right to confront witnesses against you and cross-examine through your attorney. So what that means is the witnesses against you have to come into court, testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination, the purpose of which is to try to bring out evidence that will help your side of the case. You understand that? All right, under the Constitution, you have the right to use the power of this court to now, of course, witnesses come forward and testify for you, just like the state. So if you're uncertain that witnesses that you would like to have come forward to testify are willing to come in voluntarily, it's your request. Court issues a court order, which is a subpoena that forces those people to come to court to be able to testify if they want them to, though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that? Right, Mr. Anderson, under the Constitution, you have the privilege against self-incrimination, which means you're not forced to give evidence in this matter at any time, including trial. No one can ever make a testify. The prosecutor can't, and the judge can't. It's your decision. If you decide not to testify, the fact that you did not testify cannot be dismissed in any way by any person at any time in the proceedings. In fact, no one's even allowed to talk about it, with one exception, that is if there's a jury trial, you don't testify, the judge instructs the jury that because that's your right, they cannot consider that for any purpose. Do you understand that? All right, Mr. Henderson, under the Constitution and the laws of the state, you are presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charge. So what that means is that the burden of proof isn't on you. Try to prove that you're not guilty of these offenses. In fact, under the law, you don't have to put on any evidence in your offense. You may, but you're not required. Whether you do or not, the burden of proof will remain on the state to prove your guilt and prove beyond reasonable doubt on each case, which is the highest burden of proof known under the law. Do you understand that?
Yes, sir.
All right, originally he pled not guilty, Mr. Henderson. Not guilty plea denies allegations in the indictment, denies you committed a crime, and it exercises and invokes all the rights that are described. Now, if you change your plea from not guilty to guilty, that is the opposite of not guilty plea. Guilty plea admits the allegations in the indictment, it's their crime that you committed that crime, and that plea gives up all the rights I've just described for you, except the right to have an attorney. You always have the right to have an attorney no matter what you plead. Well, that exception, your plea of guilty, gives up the right to a jury or court trial, gives up the right to confront witnesses against you and cross-examine for your attorney, gives up the right to use the power of the court to compel or force witnesses to be in court to testify for you, the same as the state. It gives up your privilege against self-incrimination because you say you're guilty, the state's not required to prove you're guilty. And gives up your presumption of innocence because you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if I should sentence you the maximum sentence, or under other certain circumstances, you could file an appeal that would have to be filed for 30 days for the sentence to intervene. You understand all that? And are you a U.S. citizen, Mr. Henderson? All right, now you have any questions about the charge, either charge or the possible penalties? You understand them?
Yes, sir.
Do you have any questions about the plea agreement? You understand it?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, what will happen if you enter that here today?
No, sir.
Is there anything you'd like to speak to your attorneys about before we go any further?
No, sir.
Do you have any questions at all about anything I've explained here today?
No, sir.
All right, then is it your decision to withdraw your not guilty plea, plead guilty to counts 1 and 2, according to the terms of the plea agreement we just went over?
Yes, sir.
Is it your decision to withdraw your not guilty plea, plead guilty to the first and second counts of the indictment according to the terms of this agreement? Okay. Then as to the charge of count 1, which Lee agrees that on or about September 8, 2020, on or about the period of April 1, 2020, continuing through September 1, 2020, in Hyden County, Ohio, you did engage in sexual conduct with C.W., not the spouse of said Matthew D. Henderson, the said Matthew D. Henderson being the natural parent, adopted parent, step parent, guardian, custodian or person local premises CW, violation of section 2907.0385 of the Ohio Revised Code, charge of sexual battery, a third-degree felony, carrying possible prison term between 9 to 60 months, and increments provided by law, fine of $10,000, requirement to register as a lifetime sex offender registrant. How do you plead? And as to count 2, which reads the same, except the date of the offense is alleged to occur on September 8, 2020. Other than that, it's the same charge and the same penalties. How do you plead? All right, the court finds on this day of the court defendant applies all constitutional rights by knowing felon voluntary waiver section of criminal 11. Please accept the court file. Defendant is found guilty of both offenses. Counts 3 to 8 are dismissed. Now, given the nature of the offenses, the recommended prison term that's in the plea agreement, the court will not order a pre-sentence investigation, and I will proceed with the sentencing forthwith. Now, before I do that, Mr. Henderson, I'm required to inform you of your sex offender registration requirements. First of all, because of this conviction, you're declared to be a Tier 3 sex offender, child victim offender registrant. That means that you'll be required to register for your lifetime once you get out of custody, and that you'll be required to verify that registration every 90 days. There'll be a window for you to do that no earlier than 10 days before that. That would be after 8 days, but no later than every 90 days. You must do that at the sheriff's office of the county or counties in which you're registered. Now, your registration requirement is that you must register with the county, the sheriff of the county in which you reside within 3 days of moving in. And if you change addresses, then you're supposed to, you must notify the new sheriff within 3 days of going to that county to register there. You may also be required to register in any county in which you establish a place of employment if you're there more than 3 days consecutively or 14 days in any calendar year. So if you're not there more than either of those times, then you do not have to register. But if you're there 3 days or more, or 14 days in any one calendar year, then you're required to register with the sheriff of the county in which you're working. You may also, if you are attending any kind of an education programming in any other county, then you would be required to register with the county sheriff of that county as well. So it's possible you could be required to register in 3 places: where you're living, where you're working, and where you're going to a place of education. Now, you have to verify, as I mentioned, every 90 days. You must do that in person. It can't be remotely or online or over the phone. You have to go in physically to the location. You're required to provide the sheriff with temporary lodging information so that if you're going to be somewhere more than 7 days, 7 days or more, such as on vacation or a health issue where you may be in a hospital or something, then you need to notify them of that place and that you'll be staying in the address and so forth. Now, if you move into another state, or if you're working in another state, or if you're attending a place of education in another state, you can also then be required to register with the sheriff's or equivalent public official that takes care of sex offender registrations in that particular state within the same time frame that I've just mentioned. If you change your residence, you have to provide written notice of that, of the sheriff where you're most recently residing, or if you're going to change your place of education, then you must also notify them 20 days before you change. With employment, you have to do it after 3 days. Because again, you don't have to register for 3 days. If you go more than 3 days, then you have to register. So the deadline for that would be 3 days after you are working in a different county. Now, under federal law, you must also report any international travel to your registering authority at least 21 days prior to travel. If you don't do so, you could be subject to criminal prosecution for the federal and state. In addition, you're required to provide written notice within 3 days of changes in your vehicle, information, email addresses, internet identifiers, or telephone numbers registered to or used by you, the sheriff with whom you most recently registered. Now, in the event that you fail to comply with these conditions, then then that could subject you to being prosecuted in the jurisdictions where you're required to register at that time. And I'm filling out here the paperwork. There needs to be a place for you to sign here to admit that you have been advised of this, so I'll have that sent out to you to sign. It's simply saying that you're aware of your requirements and what the consequences are if you fail to do so. Okay, let me make sure this sounds. All right, now, I'll go ahead and proceed with sentencing. One thing I did neglect is Mr. King stays consulted with the victim and victim's representative regarding this resolution case.
That's correct, Your Honor, and the victim's mother is actually monitoring this hearing in the Supreme Court Federal document.
Okay. All right. Now, I'll proceed with sentencing then. Is there anything that the state would like to say regarding sentencing?
The state would just ask that the court follows one recommendation. The victim's mother, that her name is April Watts, she would like to make a statement if the court will permit.
Sure. She'll need to come onto that screen. I can't see her. There she is. We need to move over a little bit more. All right. Okay, ma'am, if you would like to make a statement, you may. You're not required to. I know that you're upset, so I don't want to contribute to that. But if you would like to say something, I'll hear whatever you have to say.
Personally, this is a letter of forgiveness or acceptance. October 2020 is when I will I'm really to put it nicely, you're simply a piece of trash. People like you have no people. Sexual predators are simply that. Predators. You hunt, bring, and abuse for fun, for your own sexual gratification. You frighten me more than anyone else ever could. I trusted you with my life, my everything. You took that trust and crushed it. I will never be the same. I just don't hope to think I should be because of what you did. You took the time to point out what you were going to do. You stole my child's innocence and took away her spark, her trust. Basically killed my baby. She is not the same as she once was. Because of you, I will never have her back. I pray that this is the forefront of your mind for the rest of your life. I pray that if you are able to ever get close to another child, you will be so overwhelmed with disgust at yourself that you will be paralyzed and unable to move, except for the gut-wrenching feeling of your heartbreak and longing of your shame and guilt. You are sick. I hope that just reading this letter, you will be crushed with an agonizing guilt that darkness so thoroughly deep that you can never find your way out of it. I pray that you won't be able to live forever like your way can without repenting of your perverse sin and asking forgiveness of those you hurt. When all this is said and done, the legacy that you leave behind won't be one of joy. It will be one of anger, sorrow, and depression. People will hardly know what it is that you are. You're simply a monster in your flesh.
All right, thank you, ma'am. Anything else, Mr. King, to say?
No, Your Honor.
Sergeant Brown, on behalf of the defendant.
I would ask the court to follow the recommendation and sentence over sentence total of 9 years. Like I said, credit or not, since the day when I have done it, we'll never ever go to trial in this matter. He was never going to put this victim through anything like that. We've been open right since the beginning. We have tried to duck what had happened here or come up with some kind of flimsy excuse or anything like that. And we'd ask the court to consider that and impose the agreement on the sentence.
All right, Mr. Weicker, anything you'd like to add to that?
No, Your Honor, Mr. Armstrong said everything that I indicated. After the psychological evaluation, did nothing but open and honest, polite, courteous. I understand the acts that they committed. But again, like Mr. Armstrong said, Matt has never said, let's take this to trial. He ended up in the conduct. We asked the court to follow the recommendation.
All right, Mr. Anderson, is there anything you'd like to say? Not required to say anything, but I'll hear whatever you'd like to say. I don't have a copy of the compliance discovery from the state file. Does Mr. Anderson have any previous record?
Yes, he has a prior felony conviction, name of this is the second row. He has, out of Montgomery County, it looks like in 2012, a felony child endangerment.
Okay. All right. Well, it's the order of the court then, Mr. Henderson, that you be and are hereby sentenced to the Correctional Sentence Center in Illinois, Ohio, as to count one for a term of 60 months, according to the recommended sentence of the parties, and then to a term of 48 months on count two, again, as recommended by the parties, and it's the word of the court that the indication of the recommendation of the parties, but also the court's own finding that consecutive sentences should be imposed, and so the sentences are ordered to be served consecutively, meaning one after the other for a total of 108 months. Now, the court finds that the conduct was offensively committed as part of one or more continuing courses of conduct. There's a separate act involved, one single parent prison term not having to reflect the seriousness of the offense, and the defendant's history is such that criminal history is such based upon these convictions that consecutive sentences are necessary for protection of the public. Now, upon completion of this prison term, I think you don't have to back then.
I'll give it to you, Judge.
Oh, okay. Let me go back and look. Oh, okay. According to this year, arrest on December 15th, is that right, Mr. Anderson?
Yes.
All right, so you'll be given credit from that date, which is 113 days to get your sentence. Now, upon completion of the sentence, it is required under the law that you be supervised by a parole officer in the term set by the adult parole authority under what's called post-release control supervision for a period of 5 full years. And if during that period of time you fail to comply with the conditions that they have adopted, then they can return you to prison even though you serve the entire term set by the court for an additional period of up to 9 months for one violation, up to a maximum of half of your prison term for all violations. However, if you've been induced felony while under post-release control supervision, then an additional term sentence the judge in that new case would impose finding. That judge would also sentence you in this case for committing that offense while under post-release control to an additional period of 1 year, whatever time we left on that 5 years of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively the sentence in the new case. You're also ordered to pay the court costs, which judge grant execution order, and if you fail to do that, then the court could collect that through various means, including living on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then once you finish your prison term, you can do community service in this county. I may give credit for each hour you work in and out, or except the court, each hour you work, reduce your judgment by that would be. All right, is there anything further, counsel?
No, Your Honor.
All right, your man, you touched it, then, Mr. Henderson, thank you. Samuel McKee.
You guys waiting for the case?
Yes. All right, are you Samuel McKee?
Yes.
All right, there are 2 cases here involving the same defendant, 21 CR 200, 22 CR 27, both state of Ohio versus Samuel McKee. In case this hearing being conducted by Zoom, and he's appearing from the Justice Center, appearing for behalf of the state is Adam King, assistant prosecutor from his office. Mr. Armstrong, representing the defendant, is appearing from his office. The defendant's charged in 21 CR 200 with breaking and entering and theft, And in case number 22CR27, with failure to appear. This is the first pretrial, final pretrial set on the 20th. Trial date is the 9th of May. Discovery, looks like it's been provided and then on both sides in 21CR200, and what about in the 227, is discovery complete in that case as well?
I don't think I've asked for it, Your Honor.
It hasn't been requested yet, Your Honor.
Okay. All right, the anticipated pretrial motions, Mr. Armstrong,
No, I did not, Your Honor.
has been a written layout provided?
There is, I have not moved with the client yet.
All right, are there any other matters that we need to discuss at this time?
No, Your Honor.
All right, your attorney will be in touch with you, Mr. McKee, we'll see you on the next pretrial, thank you.